Namaste and greetings. I, Remit Arora, researcher at IMPRI, Impact and Policy Research Institute, Prabhav Evam Niti Anusandhan Sansthan Nai Delhi, extend my warmest welcome to you all to IMPRI #Web Policy Talk. We are gathered today for a panel discussion on right to information, RTI, and privacy, congruent or contradictory. This discussion is organized by the #IMPRI Center for ICT for Development, CICTD, as part of IMPRI #Web Policy Talk series. I welcome all of you to this enlightening deliberation and thank you for tuning in to this discussion. Now let me introduce the esteemed gathering for today. Our chair for the session is Professor VIBHUTI Patel ji, Visiting Distinguished Professor, IMPRI. We welcome you, ma'am.
Thank you.
The distinguished panelists for the session are Shri Shailesh Gandhi ji, RTI activist and former Central Information Commissioner, Ms. Anita Gurumurthy ji, founding member and executive director, IT for Change, Bengaluru, Mr. Apar Gupta ji, founding director, Internet Freedom Foundation, IFF, New Delhi, Advocate Dr. Shalu Nigam ji, visiting senior fellow, IMPRI. Welcome to all. We look forward to learning from our esteemed gathering. Now, without any further ado, let us start the program. It is my honor and privilege to invite Professor VIBHUTI Patel ji to start the program with the chair's opening remarks. Over to you, ma'am.
Thank you, Ramat. First of all, I would like to express my heartfelt thanks to Dr. Arjun Kumar, Dr. Sini Mehta, Dr. Ramat Arora, and whole IMPRI team for organizing this panel discussion when people are in the Diwali fervor and this issue is so mind-boggling and serious. I think we have got very good response. Welcome, Shri Shailesh Gandhi ji, Ms. Anita Gurumurthy ji, Shri Apar Gupta ji, and Dr. Shalu Nigam ji. All four stalwarts who have deliberated upon this issue thoroughly and examined pros and cons and thereby demystified the term quote-unquote privacy. As citizens, we understand that while RTI increases access to information, the right to privacy protects it instead. The right to information is a fundamental right under Article 19(1) of the Indian Constitution. In 1976, in the Radnarayan versus State of Uttar Pradesh case, the Supreme Court ruled that right to information will be treated as a fundamental right under Article 19. Right to know is a basic indivisible form of democratic polity. And this right includes right to acquire information and disseminate it. Right to information is necessary for self-expression, and it is an important means of free conscience and self-fulfillment. On the other hand, under Article 14, 19, and 21 of the Constitution, right to privacy is a fundamental right, like Justice Puthuswamy versus Sweden of India case that challenged the constitutional validity of Aadhaar scheme. As a result of this case, when revealing information under RTI, government must guarantee that it doesn't jeopardize the individual's liberty and dignity. As per RTI Act 2005, which accepts the right to privacy by restricting disclosure of the information which interferes with privacy of any individual unless it is required for a greater public good. Now the questions arise that what questions cannot be asked under RTI? On what ground RTI can be rejected? Or what are the limitations of RTI Act 2005 and which information cannot be given in RTI? Now, the public release of ChatGPT, an AI-powered chatbot by OpenAI in November 2022, have brought in new challenges. After major public debates among think tanks, tech companies, politicians, and judiciary, on 11th of August 2023, Government of India introduced a codified law on subject of personal data protection, i.e. the Digital Personal Data Protection Act 2023. And it is known as a DPDP Act. And provisions will come into force, like they have a lot of debate have happened, and a lot of questioning is also happening among the state and non-state actors. Now, it is in this context that today's panel discussion gains a major importance. And my first question is to Shailesh Gandhi ji, that what is your response to right to information and privacy? As the title of panel discussion says, are they congruent or contradictory? Over to Shailesh bhai.
Thank you, ma'am. Thank you very much. I'm indeed thankful to IMPRI for holding this discussion at all, because this is a very important discussion which needs to happen. It appears, according to various sources, that there is a conflict between right to information and right to privacy. I would submit that you can read them congruently and ensure that both rights are fully protected, and make a small presentation based on that. Who's going to help me with the presentation? Or do I share my presentation?
Yeah, you can share.
We have started sharing.
Okay, fine.
It's in a working mode. Make it
Yes.
slide share.
Yes, so fine. Right. RTI Act, privacy, Supreme Court rulings until 2010 and Constitution are congruent. This is a peculiar situation. Until 2010 or 2005 perhaps, Supreme Court rulings on right to information talk of one strain. After 2010, the Supreme Court tune seems to have changed as far as right to information is concerned, and privacy seems to be gaining great importance. Another thing I'd like to share with you, at least I know 3 Indian languages reasonably: Hindi, Marathi, and Gujarati. In all 3 languages, I'm unable to find a word for privacy. If anyone can find a word for privacy, I'd be very happy to learn that. Now, as Mrs. Patel mentioned, this is a fundamental right under Article 19(1)(a), protection of certain rights regarding freedom of speech, etc. All citizens shall have the right to freedom of speech and expression. This covers freedom to speak and express and to publish and get information. Now, once a right is given to me, it can only be restricted through the Constitution. Even by passing a normal law, without a constitutional amendment, my right cannot be constrained. Permissible restrictions on rights under Article 19(1)(a) are given in 19(2). Nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law, insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interests of the sovereignty and integrity of India, the security of the state, friendly relations with foreign state, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense. I would submit that privacy would be covered by only 2 words, decency or morality. The rest of the words do not affect privacy, is my contention. And Section 7(1) of the RTI Act categorically states that the only reason for denial of information are given in Sections 8 and 9. These are the only reasons based on which information can be denied. And therefore, my submission is privacy must be read into the law with reference to whether it violates decency or morality or not. And we'll take a look. Next slide, please. Now, Section 8(1)(j) exempts information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual, unless the PIO is satisfied that the larger public interest justifies the disclosure of such information, provided that the information which cannot be denied to Parliament or state legislature shall not be denied to any person. In reading Section 8(1)(j), all conditions will have to be looked at carefully, which is not happening in many cases nowadays. Information would be denied if it was personal information, but just being personal information, it would not be denied. Parliament was careful to understand that this would be too wide an exemption, and disclosure has no relationship to any public activity or interest, or it is unwarranted invasion of the privacy of the individual. I would submit public records are the consequence of a public activity. Why does government have any information regarding me unless it's regarding to a public activity? If it's a private activity, there's nothing on record. In fact, one retired famous jurist of India asked me, he said, Mr. Gandhi, by this logic, you are saying that you can ask what I ate in lunch today? The answer to that is very simple. RTI is to do with records. So if there is a record in the government showing what you ate in the afternoon, probably government paid for it, and therefore it's a public record. Alternately, if you paid from your own pocket, there's no chance of this being on public record, and therefore there is no issue about disclosure. But what is privacy? After the Puttaswamy judgment, privacy has become a big facade, if I may put it like this. And most people with power or the elite of the nation are more in terms of saying everything is private, information regarding them should not be shared. The Puttaswamy judgment is a huge judgment, over 550 pages, if I recall correctly. It does not exactly specify what is privacy. So how is a poor government officer to decide what is privacy? This is the question that is becoming a conundrum for people practicing transparency and privacy. However, this may be given if larger public interest justifies disclosure, provided that the information which cannot be denied to the parliament or a state legislature should not be denied to any person. In my opinion, therefore, a person who denies information under Section 81J must say this is personal information, it has related to a public activity, and it is invasion of privacy of the individual, and that he would not give it to parliament or state legislature, he would deny the information. This has been put because if something violates privacy, violates decency or morality, it should not be given to parliament, because if you give it to parliament, it becomes absolute public knowledge. Therefore, this clause was very, very carefully crafted by us when framing the act. We wanted to safeguard the individual privacy and yet ensure that all personal information does not get barred, because otherwise that would be a huge problem. There would be no transparency. Next slide, please. Now, I mentioned Supreme Court judgments before 2000, before the RTI Act came into being. And Mrs. Patel mentioned the Justice Matthew judgment, which is the first Supreme Court judgment that I am aware of that spoke of privacy, right to information for everything except things concerning national security. That was a very wide scope, and subsequent judgments have narrowed the scope but have defined the scope. Kharak Singh said any right to privacy must encompass and protect the personal intimacies of the home, the family, marriage, brotherhood, procreation, and childbearing. So it gave some kind of boundary to what constitutes privacy. Gobind versus State of MP, any right to privacy must encompass and protect the personal intimacies of the home, the family, marriage, motherhood, procreation, and childbearing. R. Rajgopal, I find, is a very logical judgment given by the Supreme Court, in which the ratio is defined as a summary to all the findings, and this is how it is being specified. A citizen has a right to safeguard the privacy of his own, his family, marriage, procreation, motherhood, childbearing, and education, amongst other matters. None can publish anything concerning the above matters without his consent, whether truthful or otherwise, in the laudatory or written. Once a matter becomes a matter of public record, the right to privacy no longer subsists, and it becomes a legitimate subject for comment by press and media, amongst others. We are, however, of the opinion that in the interest of decency, an exception must be carved out to this rule, which is a female who is the victim of a sexual assault, kidnap, abduction, or like offense should not further be subjected to the indignity of her name and the incident being publicized in press stroke media. In the case of public officials, it is obvious right to privacy, or for that matter, the remedy for action for damages is simply not available with respect to their acts and conduct. Next slide, please. All these judgments of the Supreme Court, which were before the RTI Act was enacted, fairly clearly laid down what would constitute the domains of privacy. Though we did not have a codified RTI Act, it recognized that citizens, the default mode of right to information is all information belongs to citizens and must be shared with them, except a few exemptions which have to be in line with the Constitution is by submission. Now, Section 41B of the RTI Act expects a lot of information to be published suo motu. the monthly remuneration received by each of its officers and employees, including the system of compensation as provided in its regulations. So the salary of a public official must be suo motu published. The manner of execution of subsidy programs, including the amounts allocated and the details of beneficiaries of such programs. How much subsidy was given to somebody, how much pension was given, what are the beneficiaries of such programs, particulars of recipients of concessions, permits, or authorizations granted by. DOPT Office Memorandum of 15 July 2013 said all transfer orders should be publicized through the website or in any other manner listed in section 4/4. And what is very peculiar, some of you might be aware, but some of you may not be aware, this is precisely what the Supreme Court judgment in Girish Deshpande in RK Jain and Canara Bank has prohibited, saying transfer orders shall not be shared with citizens, which is very unfortunate. Next slide, please. In Girish Deshpande, which is a landmark judgment, in my opinion, which is contradictory to the Constitution, is now forming the golden rule for denying information. In the Girish Deshpande judgment, the Apex Court held that copies of all memos, show cause notices, and orders of punishment, censor assets, income tax returns, details of gifts received by a public servant are personal information as defined in clause J of section 8(1) of the RTI Act, hence exempted and cannot be furnished under RTI Act. No reasoning was given as to how it falls under section 8(1)J. The performance of an employee officer in an organization is primarily a matter of the employee and the employer. And normally these aspects are governed by the service rules which fall under the expression personal information. Who is the employee and who is the employer? The employer, I would submit, is the citizens of India. And therefore they have a right to know about all matters regarding the conduct of a public servant with respect to his job. The details, further, the judgment says the details disclosed by a person's income tax returns are personal information which stand exempted from disclosure under clause J of section 8(1), unless it involves a larger public interest and the public information officer is satisfied that the larger public interest justifies the disclosure of such information. The very important proviso to 8(1)J, provided information that shall not be denied to Parliament or state legislature shall not be denied to a person, has been not even mentioned in the judgment. It is as if it's forgotten. No reasoning or explanation how the court came to this conclusion. This judgment contradicts R. Rajagopal ratio and ADR PUCL. The ADR PUCL, the Supreme Court ruled, this was again before the RTI Act was codified and came into existence, that citizens had a right to know about the assets and criminal charges against those who want to become public servants. That was the basis on which the ADR PUCL judgment was made by the Supreme Court of India. Now we are told that those who are public servants, citizens don't have a right to know about their assets and their salaries, etc. Which is very peculiar. To me, it is almost like saying, if a boy and girl want to get married, they must make certain disclosure about each other to each other, so that both are aware about important matters. But if they get married, then they need not make the same disclosures to each other in their lives. I find it very difficult to understand. Subsequent judgments have treated this judgment as precedent. Can you take the slide slightly up? In my opinion, the Girish Deshpande judgment should be considered per incurium, since it contradicts R. Rajagopal ratio and ADR PUCL. Subsequent judgments, nearly 4 or 5 subsequent judgments of the Supreme Court, have, without any argument, without any discussion of the law, taken recourse to Girish Deshpande and said that this all personal information is exempt, which is certainly not the law, certainly not as per the Constitution of India, and this violates the Constitution as well as the RTI Act itself. Next slide, please. Next slide. Now, another way I look at this is does the government have the right to violate the individual citizen's privacy routinely? Under extraordinary circumstances, the answer would be yes. But routinely, in routine activity, does the government have the right to violate the individual citizen's privacy routinely? The obvious answer to me is no. Hence, most information the government takes in a routine manner must not be denied to citizens. If I apply for a ration card, it's a public activity, it's a routine activity in which information that is sought should not be considered as invasion of my privacy. If I apply for a ration card, apply for concession, apply for pension, all of these are routine activities. I would go and stretch and say even income tax. Income tax filing is a routine activity. If it is violating privacy, it should not be allowed. Public records must be assumed to be not violating privacy. And this is the ratio of the R. Rajgopal judgment also. If the government is collecting the information routinely violates privacy, it should be opposed. If someone believes that the routine collection of information about a citizen is violation of privacy, this must not be allowed. This has been reiterated by the R. Rajgopal judgment, where it states, once a matter becomes a matter of public record, the right to privacy no longer subsists. In RTI, one can only seek what is on record. Hence, personal information collected routinely must be recognized as not violating privacy unless it violates decency or morality, in which case it should not be shared with Parliament as well. This is very important. Not a single Supreme Court judgment which accepts this refusal of information for 81J quotes or deals with the proviso to the law, which is information that shall not be denied to Parliament or state legislature shall not be denied to any person. Next slide, please. Now, despite this, because of the R. Rajgopal judgment, the kind of refusals are myriad. I'm just giving a few. DOPT refused a request for total number of annual performance appraisal reports of IAS officers pending presently for over 1 year, 2 years, 3 years, and 4 years, claiming exemption under Section 81J. No name was sought. The only thing that was sought was numbers. And DOPT PIO very imaginatively said it is relating to persons. Therefore, it's personal information, therefore shall be denied. Request for details of MLA funds was denied, saying it was personal information. Details of beneficiaries of PM fund, amount spent on Amit Shah's security, and so on and so forth. One of the major gains of the RTI movement was, and the RTI Act was, that it would help us to curb corruption. Our normal systems do not work. Most countries abroad in the Western democracies do not have vigilance departments in government departments. We have vigilance departments in almost all government departments. That doesn't work. So we have an anti-corruption bureau. That also doesn't work. So we have a central bureau of investigation. वो भी काम नहीं करता है. So we impose a CVC, a Central Vigilance Commissioner. That doesn't work. So we now have a Lokpal burning 20 to 30 crore rupees a year, delivering nothing. Citizens are the best monitors of corruption. And if you want to curb corruption, we've got to interpret 81J correctly, failing which it becomes an open-ended thing saying, please go ahead with all your corruption and you will not be caught. Next slide, please. Now, what has happened is that Digital Personal Data Protection Bill Act has talked of amending the RTI Act 81J, thus, and exempts information which relates to personal information. They've removed all the rest. What I've put in red and had a strike through, all this is removed. They've at least recognized that the judgments being given by Supreme Court and orders being given by commissions and PIOs were not as per the law. Now they are trying to make it as per the law. All personal information shall be exempted. That will make it a right to deny information. And person in the DPDP bill has been defined as HUF, society, company, state. Almost everything can be covered under the region of personal information. and can be denied. Will make it a right to deny information in RDI. DPDP Act must not override RTI Act Section 38.2. 38.2 talks of overriding all existing laws. If it overrides the RTI Act, then also there is a serious problem, because various things will have to be tested to see whether it is from part of DPDP or RTI Act. Our submission is RTI Act 81J must remain as it is, must be properly interpreted, and should not be overridden by the DPDP Act. Next slide, please. Exempting all personal information violates citizens' right to information beyond what Article 19.2 permits, and hence is unconstitutional. Section 38.2 and 44.3 constitute Article 19.1a beyond what is permissible in the Constitution. Citizens must discuss this and ensure that their fundamental right is not constricted. This will also severely limit citizens' actions to curb corruption. If citizens do not defend their fundamental rights, they are failing in their duties as rulers of their democracy. Share this presentation with groups of friends. Next slide, please. Okay, we'll close this. Thank you. Thank you very much.
Yeah. Thank you, Shailesh Gandhi ji, for very important presentation you made, and mainly about the fortified RTI Act. How does it curb the right to information of the public? And you also showed that how the state is denying important information in so many cases that you also cited. They were very important. Now I would like to come to Mr. Apar Gupta, and I would like to ask that your organization, Internet Freedom Foundation, is committed to advance liberty, equality, fraternity, social justice in digital spaces. What are your views on both the RTI Act 2005 and DPDP Act 2023? When IFF has filed over 24 cases in Supreme Court of India, as well as in the high courts of several states in India, can you share some of the highlights of these cases? And do state and non-state actors need to adhere to SOPs with regards to application of artificial intelligence and robotics? So these are the 3 questions. You can just choose which one to answer first. Yeah.
Thank you so much, Professor Patel, for inviting me for this panel discussion today. I'm picking up from Mr. Gandhi's comments on the interplay between the RTI Act and the right to privacy. I think some of this draws from my own past work, given that I was associated with IFF. I've transitioned just a week back, and I am only there in a governance role. But reflecting on that work, it does provide me the experience to comment on the interplay between the right to information and the right to privacy. But before I get into that, I would just like to provide a wider perspective on where the RTI Act stands today in terms of its implementation. And I think this is important for us to consider, given that the RTI Act, I think a month back, completed about 18 years of existence. And if you look at a report which was published around this by the Satark Nagrik Sangathan, which has members who are part of the NCPRI, they indicated there's a wider lack of implementation, as well as concerning distressing signals around how the RTI Act is indeed being implemented. This stems from mass vacancies, where 7 posts are vacant at the level of the Central Information Commission, where there are only 4 commissioners who are working. The credentials, suitability of persons also appointed for their positions of commissioners have also been called into question on individual appointments. There are about 3.21 lakh appeals pending with the commissioners. At the current pace, it's estimated West Bengal will take about 24 years and a month to dispose of an appeal filed on July 1st of this year. And with over 41,047 cases pending, Karnataka will take 1 year and 11 months to clear them. And it's stated that governments are not caring to appoint commissioners to the CIC and state information commissions in time. So why this is important and part of the present discussion is that I feel that it's important to also recognize the wider challenge to accountability, which is arising in India today, because the RTI is a pioneering, it's a fundamental legislation which is there to ensure that people know why decisions are being taken by government, what is the basis of that reasoning, and quite often that is being obstructed by throwing a wrench in the very mechanism of providing accountability to the people under this act. So there are wider problems which are emerging. Now, in this context of the political economy of the day of today, let me now come to what is the interplay between the RTI Act and the fundamental right to privacy. So I was one of the lawyers who was involved in the Justice Puttaswamy litigation, which emerged from the mandatory imposition of the biometric entitlement project. At least at that time, it was an entitlement project called Aadhaar. And one of the core principal objections to Aadhaar was that you're making it mandatory as a necessity for a person to identify themselves in an authenticated manner to avail an entitlement which they're guaranteed as per the very basis for which the Indian Republic exists. Our society is unequal. Everyone doesn't come from the socio-economic status that we are, owning computers, laptops, being able to participate in Zoom meetings. Most of the people are poor, illiterate, and now you're forcing a technological burden and a filter on them, which will result in exclusion. And privacy was one part of a larger challenge, which included the absence of a law for Aadhaar, which was required in a way to provide accountability. Now you're rolling out such a massive program and you don't have a statute itself, which defines the contours, which creates an organization, which makes it accountable. So it comes from that perspective. And also there were petitions also alongside that, which were on points of welfare entitlements. So we need to view it from that perspective. And here a technical plea was raised by the Union of India that due to certain inconsistency in precedent where larger benches had at earlier decades, around the 1950s and 60s, not recognized the fundamental right to privacy because it was not expressly carved out. And then subsequent cases were holding that the right to privacy existed, but were of smaller benches of the Supreme Court. It needed to be dealt by the Supreme Court to resolve and iron out this inconsistency in the court's precedent. Now, numerically, a higher judge bench decision is usually binding, but it seemed like it would not be so in the case of the right to privacy. What happened was in the Justice K.S. Puttaswamy judgment, if you read at least the opinion of Justice Chandrachud, there are repeated references to the Right to Information Act. In fact, he says the Right to Information Act has the protection of privacy. So he's drawing from the Right to Information Act at certain places as a basis in statute for the right to privacy to support his argument that the right to privacy is essential to a well-functioning democracy to ensure there's individual liberty. And individuals at the heart of the Constitution of India. For individuals also can make applications for the right to information. You don't need to convince others to make a right to information application. You can do it by yourself. And in the same way, the state can't over a certain threshold violate your privacy. Now, informational privacy is only one facet of privacy. Privacy is a wider concept under the Justice K.S. Puttaswamy judgment. I won't get into that, but it includes facets of gender, identity, sexuality, diet, religion, caste, etc., etc., etc. It's a wider concept of autonomy, personal freedom, of dignity, as the court has articulated it. Now, based on this decision, immediately there was a high amount of concern, and it was foreseeable, given the political economy as I've described it, amongst activists who have worked on transparency, the NCPRI. And people who were involved in the case around Puttaswamy judgment, and also their relationships with these same networks of social activists came together and in fact organized a campaign which was called the Save Our Privacy campaign, which is an online campaign to solicit signatures and also look at what are the complements and also the points of friction which arise. And there were joint statements, there was a workshop which was made, and I'll read out from one joint statement actually, which is endorsed by members of the NCPRI, and Anita is here, it's great to see her, it's endorsed by IT for Change. So this essentially stated when the Justice Shri Krishna committee was formed, was an anxiety that you are going to use privacy to damage the right to information, but both these rights are actually complements in ensuring there are high levels of accountability on government and democratic rights are maintained. So I'm reading this out. There are 4 bullet points in this statement, and it's stated as a statement of solidarity within the civil society amongst those promoting the rights to information and privacy. The following resolutions were passed. The citizens' right to information and privacy are both fundamental rights under the Constitution of India, and the state must protect and promote and fulfill both these rights to further democratic values and protect constitutional freedoms. There is a need for legislation on privacy and data protection in order to adequately protect the privacy of citizens, and the protections in such law should be oriented on the rights of natural persons and extend against both state and non-state actors. Third, this legal framework for giving effect to citizens' right to privacy should emerge from a pre-legislative consultation process so that the relevant legislation incorporates concerns of a wide set of stakeholders that such law will inevitably affect. Neither the recognition of the right to privacy nor the legislation of a privacy and data protection law requires any amendments to the RTI Act. The legal framework for privacy and data protection should be complement the RTI Act, in no way undermine existing statutory framework that enables citizens to use transparency for holding power structures to account. Now, subsequent to this statement, this Justice Shri Krishna Committee did come out with a draft data protection law, and it, to our disappointment, did actually suggest amendments to the RTI law. And to this, there was another joint statement which stated, and I'm reading out a short portion here. After a legal analysis, this short paragraph comes in conclusion: neither the recognition of the right to privacy nor the enactment of a data protection law requires any amendment to the existing RTI law. We therefore reject the amendments proposed to the Right to Information Act 2005 in the Data Protection Bill 2018 drafted by the Justice Shri Krishna Committee. What this shows is that, to a large extent, there is a understanding amongst communities which in fact are not distinct. I think quite often they are common, of people who have worked on the right to information and the right to privacy. And this understanding emerges from the political economy in which there is a resistance by power structures in our society to avoid accountability and to make people who lack power in society, not through statute and through institutional frameworks, be able to hold them to account. Okay. Now, let me just end this by stating that what is the actual position which is there today. The Digital Data Protection Act, which has been passed by Parliament, it's also been notified by, it's also been published in the official gazette after the president's assent, but has not yet been notified by the central government, and hence does not come into effect, has indeed amended the RTI law, which is under the Right to Information Act 2005, specifically Section 81J. I'll just read out Section 81J, explain it briefly, and then explain the amendment, which will not take me more than 2 minutes. So so thank you so much for your patience. I'm just reading it out. So if you look at Section 8, it starts with Section 8.1. And it says that notwithstanding anything contained in this act, there shall be no obligation to give any citizen. So it's saying that you should not give any citizen anything related to the things which are mentioned in Section 8.1. And then J says information which relates to personal information, the disclosure of which has no relationship to any public activity or interest. So this is purely personal information. It does not have any relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual, unless the CPIO, the Central Public Information Officer, or the State Public Information Officer, or the appellate authority, as the case may be, is satisfied that the larger public interest justifies the disclosure of such information. So what is this saying? This is saying that you cannot give this information if it is unwarranted invasion of the privacy of an individual, but you can still give it, and it becomes warranted if it is to the satisfaction of the decision-making authority that the larger public interest justifies the disclosure of such information. So it means it can invade a person's privacy, but it is justified because it has met a public interest. It further states in a proviso, provided that the information which cannot be denied to the parliament or state legislature shall not be denied to any person. So what does the Digital Data Protection Act do? The Digital Data Protection Act replaces this completely by saying that simpliciter information which relates to personal information. Now, what this does is it removes this key ingredient of satisfaction of larger public interest, or the specificity and the precedent, which disappointingly may not always be positive, but to some extent did provide certain information commissioners the ability to require information which may have links to somebody's private personal information. And theoretically now, if any personal information is disclosed by a RTI application, such as the name of a contractor who has been awarded a contract, let's say for the construction of an overhead bridge which has collapsed, okay? And it holds the name of the engineer who's inspected that site, okay? Now, it can be argued in a perverse manner due to the language as it exists on statute today that such information cannot be provided, which brings me back to where I started. It is the political economy of today on which I've been writing much more frequently and have been arguing that our recent legislations around technology are essentially demonstrating that there is a shift and a danger to our democracy towards very visible forms of centralization of power and authoritarianism. Thank you so much.
Thank you. I think very important point that you told about the centralization. The state has been empowered, the people are not. But how would you see the recent debate on artificial intelligence and the kind of encroachment to privacy that is taking place?
So it's important for us to understand how artificial intelligence is actually a label. It's kind of like a misnomer, but we use it because it's the representation of a number of different technologies, which are vision recognition, or it may be generative artificial intelligence, which relates to when we put in certain input, which gives us certain output, which may be an answer, maybe an image, maybe a video. It may also have other assisted qualities, such as image correction, enhancement, etc. So that's generative AI. Most of the debate which has emerged in India today is from generative AI. But if you look at the wider field of artificial intelligence by itself, how it relates to privacy and information, I think work which should be done much more, which has been done already to a large extent, has been the use of vision recognition in cities as a form of policing, which is around facial recognition, right? Does it actually satisfy the public policy goals for what it is rolled out? Are the implementation issues around that? Does it actually improve safety and security, or it's a scarecrow? How much money does it take as opposed to street lighting and better policing, which can be there in public spaces? Does it make people much more vulnerable because people who hold power in society get to police those who do not hold power in society to methods of facial recognition? Does it lead to incomplete context, which can lead to criminal prosecutions when there are disturbances which occur, etc., etc., etc.? So I think the debate around AI by itself, which relates to both right to information and right to privacy today, in India at least, is at a very, very nascent stage. And it's not only with respect to a debate. I think it's a complete absence of will of our lawmakers to legislate. For instance, the Minister of State for Information Technology, who holds the portfolio under the business of allocation rules to possibly consider legislation around this, has repeatedly voiced around industry summits kind of a reluctance to look at legislation or regulatory intervention or even consider it in terms of if there is a need for it. What's happening to a lot of AI around AI conversation in India is people who will have access to those technologies or even be collaborators in building around them will be the ones who will benefit more than the ones who will not. And this will result in deepening gaps and inequality, as it's been noticeable even with earlier forms of technology absorption in India.
Thank you. And also the state's role in for surveillance, applying these technologies for surveillance. We have seen hundreds of our students have suffered who took part in the Gateway of India demonstrations and all. Now, too, some of them have not received their results and their degrees. So their future is jeopardized. That also we have seen. Now, I would like to ask, thank you, Mr. Apar Gupta ji. Now, I would like to ask Anita ji. How digital technologies contribute to human rights, social justice, and equity? Because many of your research projects and your activities have been around that also. But at the same time, when corporatist and statist powers that are shaping the internet, and I think ample examples were given by the previous two speakers, what can common masses do to make these spaces more egalitarian and free from violence? How do you promote certain feminist approaches to women's digital age citizenship from your organization?
Thank you, Professor VIBHUTI Patel. I think it's an honor to be here, and also for the very, very illuminating talks. Thank you, Gandhi, Shailesh ji, or thank you also, Apar. I really found it very riveting and very informative. And what I'm going to say is going to just complement what has already been said, but indeed from also being a sociological observer of technology and its trajectory in the Indian context, I really want to unpack this on lines that have already been done, but to also show exactly the thesis that Apar laid out so well in terms of what's really happening to democracy. And in some sense, democratic values are very, very pluralistic, and, no one thing can make democracy. And so even seeing the right to information and the right to privacy as values in conflict may simply not be a useful or a productive starting point at all. So I think one thing that ties both these rights together is the principle of contextual integrity of information itself, and indeed, information as a right and privacy as a right. Actually, both are glued by the ideas of autonomy, right? The freedom that you seek cannot come to you without the freedom to express, and the freedom to express contains the freedom to seek information so that your expression is relevant to public discourse. And privacy indeed is not just a very limited right. It has many dimensions, including of physical, informational, decisional autonomy. So autonomy in that sense is very, very useful to understand this. And of course, the digital context is one really that complicates things. Theoretically speaking, it's possible to break out of the private domain and participate in the public space. You might, a few years ago, maybe a decade ago, we did a research of immigrant domestic workers in Asia, and we found actually that many of them in different countries meet in public parks because of the mobile phone in order to assert locally their right to organize. So it's truly revolutionary, right? Because you are in the private space of the home performing your public role as a worker, but you're fragmented and isolated, and you really need a public park to actually come and assert your private right to association, right? So very interesting. And these contradictions start coming up in the digital society. And so to seek information, to share experience, to deepen democracy through pluralism, pluralistic views is, I think, possible or plausible in the information society. Unfortunately, and also, like Apar described, the political economy or the powers that be in the current context, in the arc of digital society, we really see that surveillance capitalism, the state and the market under surveillance capitalism, have really not allowed the potential of digital technologies to turn out in the way in which your right to publicness and your right to privacy can materialize. So I would not only be interested in the right to information, but I would, in a larger sense, also referring to what you said, Professor Patel, about a feminist idea of right to publicness, right? You need to be visible, you need your voice to be heard, etc. So there is a bouquet of what might be termed as a loose set of rights, which are a right to publicness. So today, unfortunately, we have through the data sphere, the technologies of data, the power to break down individual behavior into, isolatable data, which then in the form of aggregate data allows the centralization that both the speakers have spoken about, which makes control possible, right? And the traditional conceptions of privacy that focus on the right to be left alone, in the sense of a zone of private action free from intrusion, is not enough to uphold privacy rights in this context. So, which is why, many jurisdictions have in the past 4 to 5 years grappled with what we now understand as the personal data protection law, or a different sets of laws in different jurisdictions. So the old dichotomy between public and private life no longer adequately describes the structural cultural conditions of digital subjects. We are very different publicly and privately, and simultaneously in public and private spaces at the same time, through also our data duplicate avatars that exist in many spaces. And all of this is not really a matter of frivolity, but I think these are extreme complexities that also will complicate the realm of the law as we know it. What is public about us is not even known to us, and this is relevant, as the previous speakers rightly said, not just for you and me, but for people who really are so disenfranchised that they don't even know where data about them and where realities and truths about them are being constructed for social control. So that the fact that the wherewithal to determine your zone of privacy no longer exists with you, no longer is available to you, is really the scary part. Because if I could build my house, build my room, and sit inside it or retire in the Himalayas, it's one thing. But if I don't even know who else is observing me at this point in time, whether as as Apar pointed out, through a remote sensing object, or even in the form of aggregate data sets, which is constructing realities about me that is unbeknownst to me, then we are talking about a very complex situation. Conversely, the public participation of individuals is not really able to establish a pluralism. We are not really seeing a public, or that's a public sphere that's truly diverse, where marginalized subjects are allowed to vocalize dissent, So in some ways, the datafication process we are seeing is contaminating the public value of our information spaces and selectively managing visibility. Who can be visible, when, for what, for spectacular, the Sully deals, that is the sense of the publicness that is manipulated. So the question here is then about enabling the public to remain a space of contested ideas, and the private to remain a space which can allow us to hone our individuality for social participation. We don't want the privacy so that we can actually do our own thing in our own ways, because we'll all turn insane, being in that isolating privacy. We need privacy that enriches, right? That empowers, that enables us to be nourished enough to participate in society, which is the Gateway of India metaphor that you used, which then is a double-edged sword. You're out there, but you're able to be, let's say, treated in a manner in which the state excess depreciates your right as a citizen. So now I just want to echo what has been actually argued by both the previous speakers, but just in a shorter way, I just want to say that today, in the context of India, at least, I would say that there is incoherence in the way the law is articulating personal data sovereignty and the agenda of territorial data sovereignty. So I really feel that there is an eagerness because of the market power of, being on the, in the data market, controlling the data market, on account of which articulations of data sovereignty tend to really come from a statist imagination rather than from a personal data sovereignty imagination. Yesterday, the center, news items covered the fact that the center is considering a directive for big tech companies to mandatorily make data, anonymized personal data in their possession, shared in government-backed databases. Theoretically speaking, the idea that, private sector should share information for public interest or public purposes, I think is a very, very valid claim. I think it's vital that entity or the sovereign entity called the corporation cannot have more human rights than human beings. But we live in an epoch when that sovereignty is somehow transferred from individuals to corporations, and therefore normatively the public underpinnings of the social data commons have to be established, that it's public and it's a social data commons and it cannot be privately held for private profit alone. But I think we are going to actually have to contend with more than just the ownership and IP, intellectual property rights of this non-personal data, because of how our Digital Personal Data Protection Act is articulated. So when privately controlled data becomes public, then we actually have to see what are the guarantees we have. And I think both the previous speakers have actually spoken extensively about what the risks are in the current articulation of the law. And therefore, without getting into the sections I thought I would read out, I just wanted to say that even in the instance of the General Data Protection Regulation of Europe, everybody is crying hoarse about the way things have gone in the digital marketplace, because everyone says, look, you're tweaking with the right to explanation, you're tweaking with, the dark patterns and the right to know, and you're tweaking with many things, but you're doing all of this so that the digital marketplace can operate without any constraint. So the idea is not for human rights to exist without constraints, but the digital marketplace to operate, what they call, the exit barriers, entry barriers, of market actors. So we actually, in one of the pieces that my colleagues wrote, they said beautifully that we have a privacy right that is a caveat emptor, buyer beware approach. That one is forced as a consumer to be watchful and vigilant. Firstly, one is not given a right. One is given some kind of privileges as a consumer, the marketplace. And even those privileges come only if you're watchful and vigilant, so that you cannot question why your privacy was violated. All you can say is that, well, on things that are not at all transparent or comprehensible, you just have to relinquish your rights. So just reading out one of these things that seems quite absurd, that the data fiduciary may process personal data of a data principal for any of the following uses. A, for the specified purpose for which the data principal has voluntarily provided her personal data to the data fiduciary. And please note what I'm going to read now, and in respect of which she has not indicated to the data fiduciary that she does not consent to the use of her personal data, which basically means that you have to really have some kind of, I think, divine ability to discern that my data may be put to use for these million different purposes. And in anticipation, you have to decline your consent. I mean, this is impossible when, the data market operates in a way as to bring out what they call innovations to seduce us, to manipulate us, etc. So we are in a situation where there is no de facto baseline of privacy. Rather, the law empowers the breach of privacy except where explicit consent is specified as not available. So you have a very limited right. You can say, I don't want this, I don't want this. You can't say, I do not subscribe to this in toto. You have to be very specific. And I think this is a crisis not only for individual autonomy. It's a kind of a, I would say it's a kind of a, by design, structural inequality, injustice, right? It's in the public marketplace. The marketplace should be a public and scrutinizable space, but it is actually designed to skew the public marketplace to maximize private ownership of information and knowledge. Now, I want to just briefly come to the Right to Information Act's implementation, which has been characterized by many of the scholars and writers who've also spoken before me. In many ways, one is that it is suffering a slow strangulation, right? What Apar said 18 years ago was the vision that powered that law, and the rights that were obtained and codified as a matter of articulation of people's experiences. One of the things I read recently was the Tamil Nadu government not accepting postal orders for fee payment in RTI applications. So they've just said, like, you can't send postal orders to us. And a poor person, may not necessarily do Google Pay and GPay and all of that. And so if you actually, and of course about tardy appointments to information commissions and the backlog, Apar actually started with things that totally shook me. So in some sense, that's a problem. We also know one important thing in technology that IT for Change is studying is about open government data. Open government data is not implemented in ways that aid citizen transparency. Usually, even taking the example of the MG and REGS, which is really pivotal to the RTI movement, we see that algorithms and backend design of the MIS is not open source, APIs are not publicly available, and nobody can access how the aggregate statistics are actually computed, because we absolutely don't have a data dictionary, we don't have the formulae, and all of this then brings us to the question that all of yourselves have actually asked. So what are we doing all of this transparency for, and for whom, right? And therefore the latest developments in the name of innovation, right? Agri-stack, health stack, all of this are supposed to have these technological protocols which will allow for so-called innovation, but basically leading to a certain enclosure of the people's data commons. And therefore I want to just conclude by talking about a couple of things. I think we see a double whammy. It's really not a question of congruence, I think the congruence is desirable for democracy, and as Apar also stated, to even start the debate as a polemical tool, it's useful to posit them as two separate things, or sometimes things in conflict. But actually, we are talking about two sides of the coin, actually, So we are seeing an erosion of the public and a subversion of privacy. And, both are, I think, serious issues. And I think we need many more of those movements towards Gateway of India. But just to talk about a couple of things and why I see this as a double whammy coming from the work of IT for Change is really that one of the things, Section 8.1J that Apar spoke about, and how several activists have come together really to talk about the transparency paradox, right? When people in power and their information has to be in the public domain, we are actually seeing a certain reversal of roles where the small person has to be completely visible at all times and summonable by powers that be at all times, right? So you're really living a life on the edge, whether you like it or not. And the citizen in small letters has the duty to remain perpetually transparent. This has been codified in the law. The duty that you have to be perpetually transparent is being codified through the consent provisions in the PDP, which is that just notice or just be aware that your consent is treated as blanket, except for those small provisions where you might actually seek to withdraw your consent, right? So this perpetual transparency is a duty. This is never what we signed up for in the social contract with the Constitution. The citizen must be made visible to the powers, whereas a right to scrutinize power is rendered illegitimate. So I think, in fact, I want to also say something that disturbs me very much. In the law, you actually, in the, the data fiduciary or the board, the data board, which is supposed to deal with complaints, there is a provision which says, and it seems very, very innocuous, but it's actually shocking for those of us who study a political economy. It says a data principal shall not register a false or frivolous grievance or complaint with the data fiduciary or the board. The imagination that the citizen of the country will go and take up the time of the data board, because our complaints will be frivolous, and the penalization by calling out this kind of thing is a public accountability gap. And therefore, what I really want to also emphasize and close with is to say that those powers in the market and state that are aggrandizing control of the public space, we really have to watch out for. And this, I think, is why privacy is important to information, and why information is important to privacy is something I want to just conclude with. So this is a democratic transition. It requires a re-articulation of our rights, and it requires a new reading of constitutionalism. Case law is very important because our constitution is a living document. The deepening of democracy and its associated publicness, which is the ability to speak truth to power, is about the right to information. But very ironically and beautifully, it's also about the right to privacy, because the idea that you can, in an era of tech-mediated community, you can cultivate association without fear. So that's why it's important. Now, conversely, the deepening of the personal space we need, the inviolable space that we can retreat into without intrusion, which feminists have called a room of one's own, cannot materialize without a right to privacy that's commensurate with the data economy. But this is also about safeguarding the public, an idea that concerns openness, transparency, coexistence, debate in a manner that genuinely leads to democratization of information. Privacy cannot materialize with the best of laws if we do not challenge the marketplace of digitalization in which both state power and market power are implicated. Thank you very much.
Yeah. Thank you. I think from the point of view of feminist perspective, it has been extremely enriching experience to listen to you. My other serious question is about the gender-based violence and the recent debate on the deep fakes. And the government of Ministry of Information Technology has also now passed a circular, and they said that as per the Technology Act, Information Technology Act 2020, Section 66D, the impersonating online is illegal and action is so. To what extent can we, as citizens, curtail this use of technology and this which is used for say perpetuating gender-based violence and misogyny both? Yeah.
I think that it's notable that a bunch of people have already moved the Bombay High Court on this Rule 3I 2C of the IT Amendment Rules. These developments that we're talking about, where it's possible to actually approach, for the state to approach the intermediary and tell them to take down content because it has been deemed through a fact-checking unit of the state to be false or fake, right? So the developments in the law are important because we're not only talking about information here or the right to information, but we're talking about truth. Who can be purveyors of the truth and whose truths count. And in that regard, and also linked to the question that you had for Apar about artificial intelligence, I think deepfakes are, one of those unfortunate ways by which we are seeing the trajectory of technologies take us into a space of falsehood and contamination of the public sphere, the perpetration of hate, the presence of material that can ignite, the kind of violence and violative actions that we see in the public sphere. I think it's a complex debate, and I do follow a little bit the debates that are, and contentious debates in Europe, also misinformation-related laws that are in process in countries like Brazil. I think a careful approach is needed. We need independent institutions. We certainly need the intermediary to self-regulate and be transparent about the ways by which they can put out metadata about things. And certainly I think the role of the state in safeguarding, I think, the rights of people, not my right to free speech cannot become, your unfreedom, right? Because my right to express myself cannot violate your space. And therefore, I think deepfakes present to us this kind of conundrum, which have to, through investments by social media intermediaries, result in, I think, advanced technology, which will result in some kind of internal policies in the corporate realm that are also transparent, put out, the nature of those things put out. I don't think, content takedowns or easy solutions like that should be resorted to, and certainly not of the manner in which the intermediary liability law, intended change of rules, not in that direction at all. But I do want to say that every change that is brought about by artificial intelligence or digital technologies that are indeed a larger bundle will require careful public deliberation. I think we cannot rush, but we do need to start the debate, and we should have started it yesterday.
Yeah. Or only after Bollywood personalities were affected, the debate has started, while husbands and ex-boyfriends and live-in partners have been using this technology to live in a very, very misogynist way.
Just in 20 seconds, I wanted to give an example. I recently spoke to the Minister of Digital of Taiwan, Audrey Tang, and she is herself a feminist activist. And she said that they've done a simple thing. Because of the metaverse, Web 3.0, there's a possibility that you can use different avatars. Shah Rukh Khan can come in and promote a product. But if somebody says that Shah Rukh Khan has been promoted by a company, in order to actually do, let's say, anti-democratic things, and the notice has been given to the corporation to take down that particular avatar, then the onus is on the company to do so. Because if the company doesn't do that, then the law will certainly take down that content. So in some ways, we have to gear up for the metaverse and the new frontiers of technology. And I think a careful calibration to keep up the democratic space is important. I wanted to give this example.
My last question to you is that you have UN consultative status for ECOSOC. So what are you doing at a global level to bring changes? Because these are most of the issues, all of them are global. And
yeah, I think more of us can do things at the global level. I think it's very exhausting. We're all, I think, holding the line, pushing the line, and we're doing it in our own spaces. Every space is extraordinarily valuable. The university space that you have served for so long, the official bureaucracy that Shri Gandhi has served for so long, Apar, who has, as you rightly pointed out, so many cases, and some of the advocacy that an organization like mine is doing at the global level. I think in the coming 2 years, the World Summit on the Information Society, which was a soft law, which came into being in 2003, is going to have its +20 review in the UN, right? So in 2025, it's going to come up for review, because it'll be 20 years of this agreement among member states of the United Nations. I think a kind of groundswell is needed for us to organize around it, articulate what kind of society we seek. Because you're very right, norms at the global level become extremely important, so that we are not necessarily only developing norms through the OECD, the G7. These are clubs, and usually the laws of these clubs then prevail over the rest of the global democracy. So I think it's important for every country and the civil society of every country to take part in these global debates.
Thank you. Now my question to the Shalu Nigamji, who is a practicing lawyer, and can you discuss some of the landmark cases in the various courts, Supreme Court and High Courts, right from 2005 till the date?
Yeah, thank you so much for giving me this opportunity, and thank you for IMPRI for organizing this conference. So I'll just start by. But the thing is that when you're the last presenter, already so many things have been said. So maybe it may be a kind of repetition, at some point of time. But I'll just bear with me. So I'll talk about RTI and the data protection law, a legal perspective. And already it has been said that how RTI is a part of Article 19(1)(a) Constitution of the Constitution is being interpreted to formulate Right to Information Act and to provide for transparency and accountability, and right to privacy. We have heard in all the three other presentations. So these are two important fundamental rights, and right to privacy allow people privacy in their personal issues, and right to information allows citizens to hold various government departments accountable for important public affairs. So, but the conflict comes in when these rights, when there is demand for access to personal information held by the government bodies. So, RTI Act itself, it has clearly defined, some of the information, disclosure can be restricted under Section 8, and if you see Section 8(1)(e), it already talks about information available to person in his fiduciary relationship. Unless it satisfied the larger public interest, such information cannot be disclosed. Section 8(1)(g), it talks about disclosure that in case if person's life is endangered due to physical safety, in that case, information can be disclosed in certain situations. In terms of Section 8(1)(h), the information about process of investigation, if in the cases in prosecution, if it is required, and Section 8 Clause 2, it clearly says that a public authority may allow access to information if public interest in disclosure outweighs the harm to the protected interest. And Section 8(1)(j), we are hearing about that, and how data protection law Section 44(3) it override this clause. So I'll just skip this reading this section again. But yeah, blanket ban is being imposed on personal information under the data protection law. So and it imposed hefty fines. So but if you see in the past, Justice A.P. Shah report, it came in 2012, and this report is very clear about it says that disclosure under RTI Act should not be constituted as an infringement of privacy. So I'll just read 3 of the important sentences from this report. It says the Privacy Act should clarify that publication of personal data for artistic and journalistic purpose in public interest, use of personal information for household purpose, and disclosure of information as required by Right to Information Act should not constitute an infringement of privacy. It says further that Section 8 of the Act lists specific type of information that are exempted from public disclosure in order to protect privacy. In this way, privacy is the narrow exception to the right to information. So when contested, the Information Commissioner will use a public interest test to determine whether the individual's right to privacy should be trumped by the public right to information. It further says that when applied, the Privacy Act should not circumscribe the Right to Information Act, and additionally, RTI recipient should not be considered as a data controller. So and if you see the case laws, the debate between right to privacy and right to information is not new. In cases pertaining to privacy of person in fiduciary relationship, just as doctor-patient relationship, in a lawyer and a client relationship, a researcher and a subject relationship, we all know that how ethics and confidentiality and other rules govern this kind of relationships. But the rule is very clear that privacy is a key component of individual autonomy, but it is not an absolute right. The provision of RTI Act, when properly interpreted, both are compatible. Privacy rights and RTI, they both are compatible. So if you go by readings, theoretically reading both the laws, they are compatible. RTI Act generally does not require to or permit disclosure of personal information to the third parties unless and until circumstances are unusual. So the question that arises that what is the meaning of term public interest? Who decide what information should be revealed, what is to be revealed, and how it has to be revealed, and what constitute public interest? So many of these questions are complex, as these involves ethic and morality. So in one of the case, the Central Information Commission, it upheld that the medical testing and the purpose of results should not be disclosed under the RTI law, as personal details of medical records have no scope of public interest. So but in case if there is the individual is at risk, if he's suffering from a communicable disease, then the information could be made public. It could be made known to the family, but should it be made known to general public? So these are the questions which arise. So the code says that there is a medical code of ethics, and we all know that there is a confidentiality clause which is there, which says that there is a need to maintain confidence should be maintained between patient and doctors. In another case, the Bombay High Court laid down the mechanism to be made before the information can be made known regarding the third party. It says that information falls within the exemption of RTI Act. Then it cannot be disclosed by the concerned authorities. But if it serves larger public interest, then only you can disclose this information. Then there was a case which when somebody was asking for the record of the public servant. So should the record of the public servant should be considered as a public interest or a private interest? So there's a lot of cases like that. And another case where the appellant sought the copies of ACR, Annual Confidential Report of the employee. Now it says that it all depends on the integrity of the public servant. So this information is being denied. Now in 2017, Supreme Court says that information sought about the employee of a bank that is outside the ambit of RTI, and because it will not serve larger public interest. Girish Ramachandra Deshpande, this case has already been discussed by Mr. Gandhi, so I will not go into that case details, but then already it talks about how the employer-employee relationship is being governed. So but the right to privacy, again, in all judgments, if you see, right to privacy is not considered as an absolute right, but it has to be seen within the context of other rights, depending on the facts and circumstances of the case. So one of the case which came is in 2014, and where the CBI sought the Aadhaar data base, and the Supreme Court ruled against it, and it says that no information can be transferred even by the government entities without the prior consent of the individual who are the owners of this information. But in another case, it says that citizens have a right to know the names of willful defaulters and the details of non-performing assets of public sector banks. So it all depends on the case, the facts and circumstances, when the courts have said that how this right to privacy and right to information, you can come to some kind of balance can be achieved. In Aadhaar ki judgment, again, we have already discussed that. But yeah, again, the dissenting judgment by Justice Chandrachud, it says that allowing the private entities to use Aadhaar numbers will lead to commercial exploitation of personal data of individuals, and without their consent, it could lead to individual profiling. So the Supreme Court, in many cases, it has held that the fundamental right to privacy cannot be construed as an absolute, but the public interest thing, that becomes important. So in various cases, the courts have said that the public authority records could only be disclosed when there is a public interest which is being involved. So the term public interest, which is coming again and again, and it has a huge scope, and how it is balanced in terms of right to information and right to privacy. These are the cases which are saying in terms of citizen surveillance and state accountability. What we have seen is that the biggest spyware is being used in past few years. How citizens are being surveillance is being used. So we have spoken about the facial recognition technologies used by the Delhi police to investigate the riots cases, and there is Criminal Procedure Identification Act, which was made in 2022, which talks about data collection as well as retention of biological and personal data. Again, this has to be looked into. Again, the digital ecosystem, the earlier presenters have said that they are talking about digitalization of personal data. So again, we have to see that how this data will be used, and this case of how a particular community is being targeted using fake online auction incident. This case has to be again seen in the context of data security. So what are the measures which have been used by the state for check and balances in case of citizen surveillance? We have seen the Citizenship Amendment Act and the protest which took place after that. And in Uttar Pradesh administration, they have displayed banners in the city of Lucknow talking about the details of the protesters, and all kind of details are being made public. The Allahabad High Court has taken the cognizance of this case, and it says that this violates the right to privacy as enshrined under Article 21 of the Constitution. Now, this case is again pending before the Supreme Court, but in the public domain, no discussion is being held on this kind of arbitrary exercise of the use of state power. And then I have some personal observation about the data protection law, as it is based on the concept of consent of the data principle to be obtained by data fiduciary. Now it assumes that all people are internet users and all people have access to internet, but it is not clear that how much practical it is when the term consent in itself is misinterpreted, manipulated, and twisted in cases pertaining to the bodily autonomy, or even in insurance cases. As a lawyer, we all know that how in the cases of rape, the consent is being manipulated and twisted over the years, even by the courts. And in terms of insurance cases, a number of cases are coming where people are just signing the insurance forms, and when they come to claim the insurance companies use various reasons to say, to deny the claims. So, these kind of things are going on. So the experiences shows that in many cases, the concept of consent is being battered, shattered, and mocked down every day in the courtrooms. Then in terms of access to digital devices and internet, when the internet usage is very low in this country, so the law is silent on how one can take consent of people who are not using the internet, but their information is there on the records, like Narega and all those kind of things we have spoken about. Then again, the definition of consent is limited. Nothing is being said about punishment to the data fiduciary if he is obtaining the consent by the use of force or fraud or misinterpretation. So what is the way ahead? What I see is that right to privacy and right to information both are fundamental rights, and the courts have somehow worked to and even otherwise it should be we should be protecting the rights of the citizen, and we should be making the state, corporate sector, and businesses more accountable. So ensuring that there should be a system of check and balance in cases relating to protection of citizens from arbitrary power, that should be there. We need to brainstorm on laws and policies on issues such as citizen surveillance, data breach, commercial exploitation of personal data on various business platforms. Again, the awareness and sensitization about the citizens about their personal data online and offline. When this the data is being misused, at various platforms, e-commerce, cryptocurrencies, and all other things are coming. I am receiving WhatsApp messages every day about, become a part of cryptocurrency and all, which I really don't want to, but then they're just forcing me. So, these what kind of protections can a person take in that kind of situation? Then we need to take up more research on social legal dimensions of RTI, data protection, and information technology law, because the concept of consent, we need to understand the consent. This concept is not very well being permeated. We need a lot of discussion and debate around this issue. So I will end this this presentation with this quote from one of the judgment by the Supreme Court in Anuradha Bhasin versus Union of India, and it says that liberty and security have always been at loggerheads. The question before us is, do we need more liberty or more security? So, but the meaningful answer is that every citizen has adequate security and sufficient liberty, and the pendulum of preference should not swing in either extreme direction, so that one preference should be compromised for the others. Here we are here only to ensure that citizens are provided all the rights and liberty to the highest extent in a given situation, while ensuring security at the same time. So I'll just stop here, and maybe we can take more on the.
Yeah, thank you, Dr. Shalunagam, for giving so many important case studies and also the examples from the actual ground level, and that also gives us hope that we as citizens can also fight against such an overwhelming system and the structures and systems which are rooted in the political economy of inequality, intersectional inequality that we are facing. There are two responses. First one is Mr. Shukla Sen. Would you like to unmute and speak? Hello? He has written in the chat box. Are you there, Dr. Shukla Sen? Are you there? Hello? He has written his response in the chat box. And the second person is Dr. Baldev Siddel. He is from Nepal, and he has also responded on the this thing about how Nepal is also getting into
Yeah,
RTI.
thanks for the invite. I don't have anything specific to tell beyond what I have already recorded.
Okay,
Thank you so
so
much.
it's written. So would you read it, or should I read in the chat box what you have written?
Why don't you read it out?
Okay. So Shukla Sen says that what has to be in this context kept in mind is that both quote unquote privacy and quote unquote transparency have two sides. I think that also came up in your presentation also. One, the right, whether transparency or privacy or of individual vis-a-vis the state and vice versa. Puttaswamy had filed his case in,
In the context of Aadhaar.
Aadhaar, yeah. Aadhaar was apprehended, would make individual unduly transparent to the state. The individual vis-a-vis state aspect must be on the top of our collective mind. We have as a rule to strengthen the individual vis-a-vis state. Yeah, that I think all four emphasize. Whether in terms of right to know or right to privacy, that has got to be bottom line. Even then, conflict arises between interest of privileged individual and commoner. Then it is a who must bat for. Then he also says the Apar has shared a paper. He has shared the link of the paper on open knowledge. And after that, I think Dr. Baldev. Dr. Baldev, would you like to speak about your experiences in Nepal? Are you there? Hello? Hello? Okay.
Hello.
Yeah, please go ahead. Yeah.
Yeah, the program is very interesting, and the right to information must be from southern to people, and that I mentioned. Sometimes the media and the media personality they exaggerate the thing. What is going on at at the community level, and if they exaggerate the thing, and if the track distorts, then it would be difficult for the government and the community the control to control the very situation that is happening and how such a type of practice could should be listened that must be addressed in certain law regulation that is usually frequently usually find in most of the South Asian country, I think
Yeah.
and in the name of right to freedom, the people should not move on either side crossing the I mean the norms and values that people have to think of it this is my opinion. Thank you very much.
Okay, thank you very much. Would any of the panelists would like to speak in the final round? Tushar bhai, would you like to respond? Hello. Would you like to speak, or should I give the concluding remark? Hello.
I think this discussion should be carried forward.
Yeah. Okay. Yeah.
And
yeah.
The way it is being positioned just now,
yeah,
the courts and everybody concerned with power,
yeah,
is that the right to information is losing its power completely.
Yeah.
Yeah.
That I think.
Which I think is a very concerning thing.
Yeah.
And in the name of privacy, right to information is becoming a larger and larger territory.
Correct. Dr. Shalu Singh, Nigam, would you like to give your comments finally? What we can do as a democratic rights people, civil liberties activists, and concerned citizens? Yeah.
Yeah, I think we need to, debate about this issue about the right to information and right to privacy. Both are important, but then we have to talk from the citizens' perspective. And, when we talk about citizens, both the rights need to be protected. So, we have to obtain a balance between these two. And basically, we have to reach out to the citizens. Common citizens have to understand, what are the implications, because sometimes, even the Google or WhatsApp or Facebook, they change their privacy policy. Sometimes, we people also, we don't read, through the entire terms and conditions. So, in that case, if we are talking, going on the grounds, how will you explain this, policies, how this privacy is going to affect you in different social media platforms? So how can we simplify this? How can we, reach out to people? So all these things need to be discussed and debated and to be sorted out, especially in the country like India, when we have, population which is majority of population is, somehow away, not talking about the global discussion yet. But, at the ground level, we have to talk about all these issues. And, so that is something which is my concern, which I want to raise right now.
And Mr. Apar Gupta, what is your this action agenda or the way forward for the participants?
I think it's what's already been highlighted. I'll just like to emphasize why public awareness is more important. Is that there has been a survey which has been done by Common Cause and Lokniti CSDS from 10,000 respondents across 12 states, and it's come out with shocking findings that people support mass surveillance, people support, at the same time, people are scared. 2/3 of Indians are scared about posting their social, political, and religious views online. And yet at the same time, they support unaccountable police powers in the digital realm. It's reminiscent of how hostages feel when their captors are there. So I think we need a renewal of values, which requires broader mass mobilization. I think the vehicle towards that will essentially be through the political parties of India. Sorry, I don't know why people don't say it, but that's the primary vehicle for at least ensuring that there's popular mass mobilization, right? Historically, that's been the route. Even for the RTI movement, there was some level of cooperation at the state level in Rajasthan, in Jharkhand, from people who are associated with political parties. So when we say civil society, it includes that that section of society, and we've done our part to some extent, also looking at trade unions, farmer unions, given that this is a broader conversation. And here I think we can take lessons from people who have been working on environment, people who have been working on gender, Dalit rights over a period of time, okay? And also ensuring that the conversations we are having here today are not only in English, they're in Hindi, in other formats. They are done much more popularly, and they are much more inclusive. I think that's also necessary, to listen to people. What are the impacts from technology? It's happening. It'll take time. That's but I think mobilization, organizing around these issues is important as a issue which is an electoral issue.
Yeah. Well, yeah, I think there is no other alternative than mobilization at a ground level. I think very important. That's, I think, now we would like to Tushar bhai, would you like to say something, or should I conclude? Hello. 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 Tushar bhai, Shailesh bhai, would you like to say something?
Oh, thank you, ma'am.
Thank you. Okay. Yeah. So now I would like to conclude and say that, okay, all four speakers, they have had a very, very important interventions in terms of what we are facing today, that Privacy Act, which empowers the state, and the Act grants power to government to exempt itself and its agencies from most requirements of Act on certain grounds such as sovereignty or integrity of India or security of the state, which are taken from Constitution of India and are cited by Supreme Court of India as the grounds on which privacy rights of the state are institutionalized. But what about people's privacy? Does it empower citizens as per the privacy principles that an individual's personal data should only be collected and used with the consent? And I think Dr. Shalonigam also brought in very important reality in which the powerless person's consent is never taken, or it is just construed as being taken, but when that person is totally powerless under threat. So defending right to information as well as digital rights demands multifaceted action towards laws and public policies, engagement with our elected representatives in the legislative assemblies and parliament, litigation and community engagement, and mass digital literacy. I think that is also very important because digital connectivity is also very important. People are facing the consequences of digital technology when they themselves don't have access to it. So our panelists and their organizations are renowned for demystifying this complexities of implications of technology and empowering the people. And the diligent advocacy for constitutional rights, free speech, net neutrality, and privacy are extremely important for deepening of democracy that we have understood. Currently, the discussion is about the deep fake, which create misinformation spreading. They are also coming up with the corrupt practices which are affected the elections that we saw even in the many European countries, and even in USA, the debate took place. Cyber terrorism, digital and corporate frauds, online obscenity and pornography, which is being discussed very hotly in India recently. Hate speeches, fake news, online defamation, identity theft, virtual forgery, all these things are very important concerns of 21st century citizens, not only in India, but globally. And when it comes to Section 16 of DPDP Act, integrating citizens' trust into the social contract of data is most important. Retired Justice V.N. Krishna, Shri Krishna had rightly cautioned, and I quote, the provisions granting exemption to the government and government bodies from all sections of the law in the Digital Personal Data Protection Act 2023 is a cause of great concern. And I think that's what all the four speakers, they highlighted. And I think it was a very enlightening discussion. And I thank all four of them from the bottom on behalf of IMPRI and on behalf of myself. Now, I request IMPRI team to take over.
Thank you, ma'am. As we come to an end of today's discussion, I, Remat Arora, researcher at IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks. On behalf of #IMPRI Center for ICT for Development, CICTD, I would like to thank all of you for attending today's deliberation. A panel discussion on right to information, RTI, and privacy, congruent or contradictory. We are grateful to our chair for the session, Professor VIBHUTI Patel, our esteemed panelists, Shri Shailesh Gandhi, Mr. Anita Gurumurthy, Mr. Apar Gupta, and Advocate Dr. Shalonigam, for taking part in the discussion and enlightening us. We thank all our participants who have raised pertinent questions and actively participated in today's deliberation. We are grateful if you're watching us later on our YouTube channel or listening to us on our various podcasts or reading our publication. You may also find more thematic events and book discussions under IMPRI Web Policy Talk series. We hope you continue to join in the future to our IMPRI Web Policy Talk and Web Policy Learning. Wishing you a good evening. Thank you.
Thank you, everyone.
Thank you.